Yes, good evening to the participants of the JCJ 2022 main examinations, and I posted something on the screen. Please, participants, you can unmute and read that what I posted on the screen.
Welcome to the aspirants of JCJ 2022 main examination 17-11-2022 date. Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, PO Box number 307, Malibi, Muzwa, Tanzania, East Africa.
Malimbe, Mwanza, Tanzania, East Africa. So let us, without wasting the time, that we go to our continuation, that is the sufficient cause. What is meant by sufficient cause? The term sufficient cause has not been defined anywhere. Let me close this one. Yes, has not been defined anywhere, but as held in the case of the UCO Bank versus Iyengar Consultancy, it is a question which is determined upon the facts and circumstances of the cases. The test to be applied for this is whether or not the party actually and honestly intended to be present at the hearing and tried his best to do so. There are several instances which have been considered as sufficient cause, such as a late arrival of the train, sickness of the council, the strike of advocates, death of the relatives of the party, etc. So now we will see that is made it very much clear in the UCO Bank versus Iyengar Consultancy. What are the sufficient causes? Late arrival of the train or bus, sickness of the council, the strike of the advocates, death of relatives of the party, etc. They are supposed to be a sufficient cause. Now the burden of proof that there was a sufficient cause of non-appearance is upon the defendant. So burden of proof on whom? The person who wants to defend it. Am I right? And who did not attend on the summons day, on the trial's day.
Yes.
Even though the summons are served.
Yes.
The
Section 25 of CPC.
Yeah, please.
No, summons, I said section 25 to 29 deals with summons. Order 5 deals with the summons.
Okay. But here, intentionally, he did not appear for the trial, or is there any sufficient cause? So that is what we are going through, the sufficient cause just now. Commissions. Section 75 to 78, Order 26. What is meant by issue of the commission by the court? Commission is instruction or role given by the court to a person to act on behalf of the court and to do everything that the court requires to deliver full and complete justice. Can I say the commission is a mobile court where a person goes to a particular area and act as a judge and report to the original judge?
Actually, there is nothing called mobile court.
I'm giving the different idea. Oh, your house talk could be your thing to me. Okay, now the commission, a commission means a court cannot go to a particular area where the dispute is there. And hence, the court will appoint the commission. The commission go over there and act as a judge or a magistrate and give the report as if the court has went over there. Am I right?
It is like court appointed officer.
Yes.
Or a receiver.
Yeah, appointed a person and he goes there and he can give the complete report so that the delivery and justice could be done. Such persons who carries out the commission is known as a court commissioner.
Court commissioner, yes.
For the commission appointment, who has to bear the expenses?
The court will pay, but recovery will be done by First, the court will pay.
Yes, yes. Court will pay to the commissioner, but amount will be reimbursed to the court. Commissioner amount.
Yeah.
And is it not? By the other party.
Yes, yes.
For example, whenever the court has to do a local investigation, a commissioner is appointed who conducts the local investigation. Similarly, to record the evidence of witnesses who can't come to the court for evidence, the court can issue a commission for recording of even the such evidence also. And who can appoint a commissioner? Under CPC, the court which issues the commission can appoint the commissioner. Section 75 provides that the court can issue commission provided the limitation and restriction applicable. Therefore, the court who has to decide the suit can appoint the commissioner. Commissioner is appointed to carry out the functions for which the commission is issued. Court has the discretionary power to appoint the commissioner, and such power can be exercised on the application of any of the parties, or the court can issue the commission suo motu.
Yes.
We will understand the procedure followed by the court to appoint the commissioner later in this article. Okay. Who can be a commissioner? I am sure. Who can be appointed as a commissioner? Generally, a commissioner within an advocate, but a senior counsel doesn't, of course, senior counsel will not obey it because it's a lawyer to the degree, and the juniors will be generally accept the commissioner. Am I right?
Normally, they'll take an advocate who understands the proceedings of court,
Okay.
who understands the law,
Okay.
who's matured enough.
Okay.
So that kind of person, the court appoints a commissioner.
Okay.
What happens?
Yeah.
If they appoint a junior person, he doesn't understand law most of the times. So in such cases, they don't appoint juniors as commissioners. They appoint senior people, at least person who's having 15-20 years of experience and who has a credible in the court and who has won certain cases, or who does argument very well, or a person who does the interpretation of law very well. Such person will be appointed as commissioners.
So it is the court will decide to whom it should be.
Yes, yes.
Generally, there is a panel of commissioners which is formed by the High Court, in which advocates are selected who are competent to carry out the commission issued by the court.
Yes.
Now, the person appointed as a commissioner should be independent, impartial, disinterested in the suit and the parties involved in it. Such a person should have the requisite skills to carry out the commission. As you said, no, he should have the full maturity in the particular case where he can justify it. It will be a complete waste of time and resources of the court and the parties if a person who can't read and understand the accounts and documents is appointed as a commissioner to adjust the accounts. In case it's the accounts case, that means the person will be well versed in the accounts and will be appointed as a court commissioner. Similarly,
Yes.
a person who does not have the qualification to conduct scientific investigation could not be appointed as a commissioner for such a task. That means
Yes.
the background of the commissioner also will be taken into consideration, what he studied in the graduation level. Am I right?
वो तो ठीक है. Example, अगर मान ले, if the court has to do some auditing of accounts,
Yes.
तो उसको तो बैलेंस शीट पढ़ना आना चाहिए. सबसे इम्पोर्टेंट.
Yes.
Most of the people बैलेंस शीट पढ़ना आता नहीं उनको.
Yes.
कि पैसा कैसा घुमा सकता है बैलेंस शीट में, कौन से एंट्री कैसा मारा इसने.
Okay.
ये कब आएगा आपको, unless you have experience, जैसे ना requisite experience.
Okay.
Such kind of people given certain that kind of task job.
Okay. So now,
Scientific का जो, yeah, go ahead, sir. Sorry.
okay. I appreciate your explanation. The district judge supervises the subordinate courts who have to take the special care while appointing a commissioner. That means the subordinate courts who are appointing the commissioner, the district court supervision would be there. The same person should not be appointed by the court in all commissions, and a person who hangs about the court shall not be appointed. Means a person who is a lazy would not do it and made the court to hangs for some more time, and such person would not be appointed, and the same person cannot be appointed for several times as a commissioner. What is the procedure for appointment of a commissioner? Every high court has the power article and by virtue of the article 227 to make the rules and regulations which is to be followed by the subordinate courts. Procedure for the appointment of a commissioner is provided in the high court rules each state. Is it civil practice of rules or criminal practice of rules or separate rules of practice?
Civil practice they have to.
Okay, I understood.
For amicus query and all this thing, they take people with criminal knowledge and civil knowledge.
Plus, they may take even academicians also.
Yeah, academicians. But example, if you look into this, whether rape can be considered for marital sex.
Okay.
What happened nowadays? Marital issues don't come under the rape.
Okay.
So in such cases, they take amicus curiae person who has well experience in constitutional laws, in family laws, criminal laws.
Okay.
Whether marital rape can be considered as a rape or not, or if it's any international issues, then Constitution of India, international courts and all these things they'll take. They appoint commissioners.
Okay, these are the points on how a commissioner would be appointed. For instance, in Delhi, Chapter 10 of the Delhi High Court Rules, 1967, provides a procedure for the appointment of the commissioner. The following procedure is followed by the Delhi High Court. Now let us see what Delhi High Court has followed. A panel of not more than 4 commissioners is to be formed, which consists of young persons, including a lady lawyer, appointed by the court for recording of evidence. And next, the district court notifies the bar about the number of the vacancies of the commissioners, and the bar forward the application received for the same to the court, who then forward it to the High Court with their recommendations. The term of such appointment is generally 3 years, which can be extended by an order of the High Court, but no commissioner can be appointed after the 6th year of such appointment. Okay, the duration, the tenure. When can a commissioner be appointed by the court? A commissioner can be appointed by the court when a commission is issued by the court. According to Section 75 of the CPC, the court has the power to issue a commission to carry out the following functions: to examine the witnesses, Article 26, Rule 1 to 8, the general rule of evidence to bring the evidence before the court and must be recorded in open court, but in extraordinary circumstances, the appearance of the witnesses is dispensed and the witness is allowed to depose evidence without appearing in the court. Is it the court permission should be needed, or depending upon the witness's nature, it can be dispensed from appearing in the court? For instance, he is on bed because of PPT, that is, what is the plaster of Paris? Is it plaster of Paris? Bandage to the leg.
Yeah. वो प्लास्टर ऑफ पेरिस लगा था ना, हाथ पैर जब टूट गया तो कुछ जोड़ने के लिए.
That fellow cannot come over there, neither he can sit on the wheelchair also, because it is from the thigh upper part to the lower part of the ankle.
Yes, yes.
So appearance is exempted if now they are giving the situations, context. A witness is bedridden or is unable to attend the court due to the sickness or infirmity. In such circumstances, the court can exempt the appearance of the witnesses and allow the witnesses to depose evidence to a commissioner appointed for the same. What about the full months pregnant women who could not move?
Even, but this is what you're saying with regard to the law.
Yeah.
But nowadays, the law also has changed drastically after the COVID-19.
Okay.
People who say that I cannot come to the court, video conference karo.
Okay. Direct face to face that you can see.
Yes.
And who can say and what he is saying or what other things are there.
And that will be a recording evidence also.
Naturally.
क्या होता है कमिश्नर कुछ और पूछता, ये कुछ और इंटरप्रेट करता है, कमिश्नर कुछ और इंटरप्रेट कर लेता है, वो कुछ और लिख देता है, वो साइन कर देता है.
Now they can hear from the horse mouth.
Yes.
So such a witness will have to submit a certificate signed by the registered medical practitioner as evidence of sickness or infirmity. Order 26 Rule 1 CPC. In situation the court will exercise its power provided under Order 18 Rule 4 and appoint a commissioner for examination on interrogatories. So a witness apprehends the danger to his life and informs the court about such danger, and if the court thinks that recording evidence of the witness is necessary, the court may issue a commission to record evidence of such a witness. Where a party accused of fraud seeks himself to be examined with the commission, the court must not issue the commission and avoid the person of such a demeanor to abuse the procedure. The witness is a Pardanashin lady and whose attendance is exempted under the section 132 of the code. The witness is a civil or a military officer of the government, cannot attend without the detriment to the public service. That is Order 24 Rule 4. If the court thinks that it is in the interest of justice or expeditious disposal of the case or for any other reason, the court can issue a commission notwithstanding any of the rules provided in the order. It is very self-explanatory. What are the grounds? When can a commission would be made? And Order 26 Rule 4A.
But अगर आप मुझसे पूछेगा तो ये appointment of commission is nowadays it's useless.
But a procedure is there now to appoint.
But because of changing in technologies.
Yeah, this thing should be changed later on.
अभी technology इतना changes आ गया है, and now you have online courts, everything.
Yes.
So a person can appear physically from wherever, even if he's on the bed.
Yeah.
Bedridden also, he can do video call.
Naturally. So these are the theoretical point of view. We have to study it. And now application is concerned, that would be the different. That's why you can say theory and practice.
Yeah.
A person who can't be ordered to attend the court in person under Order 16 Rule 19 can be examined by the court by issuing a commission. That is Order 26 Rule 4 proviso. A commission can be issued for examination of a person detained in the prison. Order 16 capital A Rule 7. Because if that fellow brings out there is a much and hue and crow, there is a more possibility that he may kill even the people those who are taking him in the chain. And such a situation comes, better we take the examine in the prison itself. Am I right?
Yeah, they'll set up special courts for such kind of persons. Like example, that Kasab person who did. So they cannot bring him every time to court.
Yes, no, because it's again law and order problem.
So what the court goes to the jail only, or they'll tell him video conference laga uska saath.
Okay. Yes, that can be done. So the court will issue an order of commission for examination of a witness on the following grounds if such person under Order 26 Rule 4 resides beyond the jurisdiction of the court, Order 26 Rule 3A, ever to leave from the jurisdiction of the court, Order 26 Rule 3B, a government servant and cannot attend without affecting the public service, Order 26 Rule 4C, resides outside India and the court decides that his evidence is necessary, the commission will be issued to any other court within whose local limits such a person is residing, and if the person resides within the local limits of the court issuing it, a commissioner can be appointed to carry out such commission. So, if it is beyond the jurisdiction would be there, they do follow the other, they will give the direction to the other court where the jurisdiction falls over there, and the commissioner would be made in such a way. I don't know if a person is living in the United States of America and whose evidence should be needed over there, but now they can use the, as you said, the IT technology. Is it not? IT. The provisions of the code relating to the summoning, attendance of examination witnesses, penalties imposed on the witnesses will apply on the person who has to give the evidence or produce the documents before the commissioner. The commissioner who is executing the order of the court within whose local limits such a person resides or by the court beyond whose jurisdiction such person resides will be doomed to be a civil court. Of course, the different situation is given over there, and if the person is living beyond the jurisdiction and how it can come, what are the procedures should be followed. Yes, if the commissioner is not a judge of the civil court, the commissioner cannot impose a penalties but can make an application to the court which has issued the commission to impose a penalty on the person. In case he is not a judge of a civil court or doesn't have that much knowledge regarding the punishment imposing, then he can give the report to the court, and the commissioner will give that report to the court, and the court will impose the penalties on that person. That is Order 26, Rule 17. So now if you go further to make a local investigations, Order 26, Rule 910. The court can appoint the commission for local investigation if the court is of the opinion that a local investigation is necessary. Suppose if they say the wall is in my land and the other opponent say no, the wall is in my land, a dispute would be there, and where the wall, where the land, and such a thing, then an investigation to be made, a commission would be appointed, and whose land the wall is there. Am I right? For proper clarity of any matter in dispute, or in ascertaining the market value of any property, or to know the amount of mensiria or annual net profit, mesne profit or mensiria?
Actually, mesne profit. Mensiria likha hai.
No, it's a mesne profit actually, because that's also.
So mesne profit hai.
Because unnecessarily holding the mesne profit. This is the way.
Yes, mesne profit.
Holding the land, holding the house and returning the house rent or returning the harvest of the land by making the false possession of it, and that is a mesne profits or annual net profit. Mesne profit or annual net profit that should be given to the person who is the real owner of the property. While appointing a commissioner for the court has to examine what is, number one, the pleading of both the parties, relief claimed, the real controversy between the parties. It should be noted down. It is important to note that the object of a commission is not to collect the evidence which can be brought to the court by the parties to acquire evidence from a fixed spot. It is also used to enable the court to have the more clarity regarding the facts of the case. That is an important aspect of it also. Commissioner should not be appointed to provide a pre-trial decree against the defendant. That is, the court should not appoint a commissioner to provide the relief claimed directly or indirectly by the plaintiff before the final decree is passed. It is important because such commission will prejudice the right of the defendant to a fair trial. It's good. Now let us see to adjust accounts, Article 26, Rule 11 to 12. In a suit, if the court thinks that it is necessary to verify the accounts involved in the suit, the court may issue a commission to make the examination of such accounts and may appoint a commissioner. Rule 11. The court takes a special care while making such an appointment. The court appoints only such a person who is competent to examine such records, means accounts. The report submitted by the commissioner is considered evidence by the court, that is the Rule 12. To make partition, Article 26, Rule 13 and 14. The court can issue the commission for partition of a suit property. Suppose the court has passed a preliminary decree for partition of the suit property. In such situation, the court can appoint a commissioner to carry out the decree, that is the Rule 13. The commissioner has to divide the property in shares and distribute it among the parties according to the suit decree. The commissioner has to submit a report after such a partition is completed. That is Rule 14. Yes, if an assignment is given over there and if it is over, the report should be submitted to the person who has appointed him.
Yes.
So now let us see that to hold the investigation, Article 26, Rule 10, capital A. When the court has to conduct a scientific investigation, the court can appoint a commissioner who will then be responsible for such an investigation. For example, to identify the substance used as a raw material in the subject matter, the court may issue commission to hold a scientific investigation, that is the Rule 10, capital A. What about the ballistic forensic science? Forensic science.
Answer?
Forensic science.
Forensics, na?
Is it how a person was killed? What instrument is used? Whether he used ammunition?
Both the forensics department. Yes.
And what type of the bullet it is? Ballistic.
That will be given by the forensics department.
What about the ballistic?
Everything. Forensics. They come, na?
Okay.
कौन सा गन से इस्तेमाल किया है, उसमें कौन से बुलेट का बुलेट कौन से एमएम का है?
What is the range? How much range? What is the size of the bullet?
हाँ, वो सब बताएंगे वो लोग. These are experts, na? These are experts in their field.
So experts' opinion taken from them.
Yeah, like Hyderabad, they have India's famous forensics lab.
Yeah.
Hyderabad ka.
Yes. After conducting such an investigation, the commissioner has to submit the report with the times prescribed by the court to sell the property. Article 26, Rule 10, capital C. Suppose the subject matter of suit is immobile property which cannot be preserved by the commissioner, and if it is not sold, its value cannot be recovered. Therefore, the court appoints a commissioner who is given the responsibility to sell the property and submit the report along with the proceeds received from the sale of such a property. When the movable property is perishable in nature, like tomatoes, only that property.
Vegetable items, fruits, vegetable, fruits, all these items
Yeah,
which
yeah,
are perishable in a day or two.
yes, yes. To do ministerial work, Article 26, Rule 10, capital B. Ministerial work means the administrative work which the court has to do, but are not of judicial nature like accounting calculation. Such work takes a lot of valuable time of the court, which can be used in other important judicial functions. Therefore, the court appoints a commissioner to do such works. On behalf of the court, it is important. Srinivas Sake is waiting in the lobby. Okay. Therefore, the court appoints a commissioner to do such works on behalf of the court. It is important to note that the commissioner cannot do judicial functions. Only ministerial functions are given at that time. Only that functions can be taken by the commissioner.
It is like administrative functions they can do.
Yes. And I believe that is specifically mentioned there also, why he is appointed and what to do.
Yes, yes.
And there would be a parameter also to him.
What is supposed to do, what is not supposed to do. He cannot give any interim relief. He cannot lay fine on anyone.
Okay.
He cannot give any judgment. He is there only to go for a fact-finding mission.
Yes. Now
That is
let's
the
see the
purpose of commission.
Yeah. Shall I proceed?
Yes, sir.
Procedure for carrying out the commission. The commissioner will conduct the local investigation, examination of the witnesses, adjust accounts, and other functions as ordered in the commission. After completion of the function, the commissioner will reduce the findings in writing and will make a report. The commissioner will submit the report signed by him along with the evidence recorded in the court. The report of the commissioner will form a part of the record. While examining the report, the court or the concerned parties, after prior permission, can examine the commissioner personally in open court.
Yes, he also will be subject to evidence questioning also by the party.
Okay. That means he's accountable for whatever he did it.
Yes. He is directly accountable.
If the court is dissatisfied with the proceedings of the commissioner, the court can order a further inquiry on the commission or can issue a fresh commission and appoint a new commissioner.
Yes.
To summarize, the commission can be issued in the following circumstances. 1. To make a local investigation. 2. To adjust the accounts. 3. To make the partition. 4. To hold the investigation. 5. To conduct the sales. 6. To perform the ministerial work. 7. Powers of the... only 7. 1, 2, 3, 4, 5, 6. Only 6. Power of the commissioner. Article 26, Rule 16 to 18. Under Article 26, Rule 16, powers of the commissioner are as follows. What are the powers? Now let us see. Commissioner has the authority to examine the parties and the witnesses and any other person who the commissioner thinks can give evidence in the matter referred to him. 2. Commissioner can direct the parties to produce any documents which is required to be examined. 3. Commissioner has also the power to enter and search any land or a building with the permission of the court. Next point. If the party fails to appear before the commissioner, after the order of the court, the commissioner can proceed ex parte. So that power is given to him.
Yeah, he's like more or less, he has the civil court powers.
Okay. But again, the ex parte is given, it is not a final and conclusive judgment. Again, it can be condoned also, provided the sufficient ground is shown by the opposite party. Whether the commissioner,
what it says, the commissioner can proceed ex parte. He cannot give ex parte orders.
Yes.
He cannot give ex parte orders. He can proceed ex parte.
That's all. Whether the commissioner will be entitled to a remuneration, answer is Yes, honorarium. There is no provision in the CPC which expressly provides the remuneration to the commissioner, but Rule 15 of Order 26 provides for certain expenses which might be incurred by the commissioner. While issuing the commission, the court directs the applicant to deposit a sum of amount which can be used by the commissioner to account for the expenses which might be incurred by him while carrying out the commission. Suppose the amount which is less but the amount which he has paid is more, can the court will pay from their own pocket?
नहीं ऐसा होता है सर कि कमिश्नर को जो ट्रैवल रिइंबर्समेंट रहता है ना,
Yeah.
that will be at actual.
Okay.
Because अगर कमीशन बोलेगा I will only give you 100 rupees, you go and do the investigation, कहाँ से करेगा? 100 rupees में उसको जाने को नहीं मिलेगा.
Naturally.
आएगा कैसे फिर वो? So normally the transportation will be at actual. It will be bus, AC bus or local bus, local taxi, third AC, but not flight. Okay. And खाने का amount fix कर देते लोग. Per day you'll get 250 or 300 rupees कुछ रहता है per day.
Okay.
And local stationaries का कुछ पेपर खरीदना है, पेंसिल खरीदना है, वो एक लमसा अमाउंट रहता है एक. That's all. He cannot go to a 5-star hotel, eat lavish food. He cannot go in a lavish train or in a lavish luxury Ola book किया, Uber book किया, मैं जा रहा हूँ नहीं. He has to use public transport.
The purpose was to test.
Okay. The court has a discretionary power to make a direction regarding the remuneration. What are the limitations on the commissioner? Commissioner has to assist the court in carrying out the judicial functions, but he cannot do the judicial functions on behalf of the court. For example, a commissioner cannot value the suit property because it is a judicial function and only the court has the power to do so. A commissioner can assist the court by producing the documents such as the plans of the suit property by which the court can ascertain the value. So, he can assist. It is not the objective of issuing a commissioner to procure the evidence for the parties. Therefore, if a party has the apprehension that the opposite party will tamper with the document which is relevant to the case, the court should not appoint a commissioner to see such a document. The court should not appoint a commissioner to such a document because he is
to see such documents.
Okay. What is the evidentiary value of the report submitted by the commissioner? According to Order 26, Rule 10, 2 of the CPC, the report and the evidence submitted by the commissioner forms a part of the record, but if the evidence is submitted without the proof of the commissioner, without the report of the commissioner, such evidence does not form a part of the record. So, a recorded statement in the must be there with the evidentiary value.
Yes.
The report forms an important part of the case and can only be challenged on sufficient grounds. The court has a final say on how much reliance should be placed on the report submitted by the court. Yes. Next, a receiver. Order 40. Who is the receiver? Under the Civil Procedure Code. Under the Order 40 of the CPC, the receiver is an independent and impartial person who is appointed by the court to administer, manage, that is, to protect and preserve the disputed property involved in a suit. For example, in a dispute between A and B for an immovable property, if the court thinks that it is in the best interest of both the parties that possession should be taken from B and given to an independent person, the court may appoint a receiver who can manage the property till the time the suit is being decided. Such a receiver appointed by the court would be responsible for the maintenance of the property. He can collect the income accruing like a rent or any other profits and utilize to maintain the property. After deducting the expenses incurred in maintenance from the income receipt from the property, the receiver will have to submit the remaining income, if any, in the court. So he should be answerable for that one to maintain the property. Whatever the amount will be incurred over there, that will be deducted from the profit which is accrued from that land or the house. He is not a representative of either of the parties in the action. He is uniformly regarded as an officer of the court working in the interest of the neither the plaintiff nor the defendant, but for the common benefit for all the parties to do the justice. What is the purpose of the appointment of a receiver? When a party in possession of the disputed property exhausts the property or causes irreparable damage to it, the whole object of the suit gets defeated because of such a subject matter ceases to exist or its value gets affected. Therefore, when the court is of the opinion that the property in the dispute must not go to either of the parties pendant alike, the court appoints a receiver who is entrusted with the protection and preservation of the property. It is a form of interim protection which the court provides to the parties to make the application till the time the court adjudicates the matter. So in such situations, the appointment of a receiver is must.
कंप्लीट करना करती हूँ ना वो भी
Oh, that word is I am hearing. What is the role of a receiver? A receiver is regarded as an officer of the court and is extended arms and hands of the court. He is entrusted with the responsibility to receive the disputed property or money given by the court and manage such property or money till the time a decree is passed or the property or the parties have the compromised or any other period as the court deems fit. To that extent, the role of the receiver would be there. If once the matter is issued, the role also comes to end. The property or fund entrusted to the receiver is considered to be the custodian, and that is the custodia legis, that is in the custody of the law when it is given to him. The receiver has no power other than those entrusted to him by the court while appointing him. So the court will say what to do with the property, and he could not misuse the property or he could not use for himself or herself. Who can appoint a receiver? According to the Civil Procedure Code, the court before which the proceedings are pending can appoint a receiver if it appears just and convenient to the court to appoint such a receiver. Because when the case is in the hand, at the time, the court deems fit that a receiver should be appointed. Otherwise, the value of the property will be diminished or tampered by the parties who is in the custody of such property. Section 51D, it is a within the discretionary power of the court to appoint the receiver. For example, in a suit, the trial court can appoint a receiver, whereas in appeal, the appellate court can appoint a receiver. Very obviously, self-explanatory, no dispute. However, the discretion is not absolute, arbitrary, or unregulated. The expression just and convenient does not mean the appointment is based on the whims and fancies or the whims and wishes of the judges or any ground which stand against equity. Of course, there would not be any arbitration and there will be clear-cut provisions to be there and whims and wishes will not be comes over there. So, it is, it should not be arbitrary, it should not be discretion or unregulated. These are all the norms to be followed. How does the court decide whether to appoint a receiver or not? Court has to keep the following principle in mind before appointing a receiver. What are the appointment of a receiver is a discretionary power. It is a protective relief to the plaintiff. The object is to preserve the disputed property till the time suit is pending in the court. A receiver not to be appointed unless the plaintiff shows prima facie that he has a strong case against the defendant and is more than likely that he will succeed in the suit. So appointment of a receiver is one of the hardest remedies as it deprives the defendant of his right to possession of the before the final decree. Therefore, the court should not restore to it merely on the ground that it will do no harm. So that is the purpose of the appointing the receiver. So that the property will not be, value will not be diminished and it will not be tampered. There should be strong apprehension that there is a danger to the property, or the plaintiff will be the worst of a situation if the appointment of receiver is delayed. So in that occasion, the receiver will be appointed. Am I right? The court should appoint a receiver only when there is a possibility of wrong or injury. Also, if it is shown that the subject matter is not in the possession of any of the party and it is in the common interest of the both, let the property would be in the hands of the receiver, and he is a third person who is not connected with any one of the party. The parties to appoint a receiver for the protection and preservation of the property. So that is the motto behind to appoint the receiver. The court should look at the conduct of the party and who makes the application of the appointment of a receiver. The party should come to the court with the clean hands, and their conduct should be such that they are not disentitled to his equitable relief. A person who goes to the courts goes with the clean hands, that is the equity principle. So here the person who is appointed, he should have to be very much clean without any having biasness in the dealing the case. The above principle were introduced by the Madras court in the case of T. Krishnaswamy Chetty versus C. Thangavelu Chetty and others, year 1950, Madras 430 page. These principles are now well established in the Indian jurisprudence. Who can apply the appointment of a receiver? Generally, a plaintiff files the application for the appointment of a receiver, but defendant can also file such an application. A third party is not allowed to file the application, but if he is interested in the protection and preservation of the property, he can also make an application after taking the permission from the court. Otherwise, the party who is connected with the dispute should file the case. A third party can also file a case to preserve the property, but he has to obtain the permission from the court. Who can be appointed as a receiver? A person who is an independent, impartial, and totally disinterested to be appointed as a receiver. Such a person should not have any stake in the disputed property, share in the disputed property, vested interest in the disputed property. So such person can be appointed. Generally, parties to the suit are not appointed as a receiver. So parties to the suit, they cannot do the justice appointed as a receiver by the
कोर्ट क्यों आते हैं?
Yes.
अगर parties to the suit, if they are appointed as receiver, why will they come to the court?
It is an obvious factor. But in extraordinary circumstances, a party to the suit can be appointed as a receiver. I don't know what are the extraordinary circumstances will make the party to the suit can be appointed as a receiver, provided the other party should have to accept it also. Otherwise, they will make an objection. Of course, both parties will agree it, no matter at all. Am I right?
Yes, yes.
There is a saying is there, Mia Bibi Razi to kya karega khazi.
Hazi.
When can a receiver be appointed? The court can appoint a receiver when the court is of the opinion that either the party should not hold the property in dispute. Na tere paas rehna, na mere paas rehna. The property should not be with you, not with me. Better would it be with the receiver. The court can appoint a receiver before or after the decree and can remove any person from the possession or custody of the property and commit the same property in the custody and management of the receiver. Even after the decree, if there is court deems fit that let the property neither with the plaintiff nor with the defendant, let it be from the third person who is appointed, and let all the management of the property and custody should be given to the receiver. Under the code itself, the receiver can be appointed to prevent the ends of justice being defeated. Section 94D. Similarly, for the execution of a decree, the court has the power to appoint a receiver. Section 51 small d. There are provisions in special acts which provides for the appointment of a receiver. The court, by the court. So CPC is very much clear that which order, which section, and which rule make all these activities. For example, Section 84 of the Companies Act 2013 provides for the appointment of a receiver. Similarly, Section 69 capital A of the Transfer of Property Act 1882 also provides the appointment of a receiver. What is the process of appointment of a receiver? The process of appointment of a receiver is provided by the courts in their respective court rules, that is the civil practice rules. The High Court has the power to make the rules for the superintendence and control of the subordinate courts. For instance, in chapter 19 of the Delhi High Court Original Side Rules 1967, the following process is provided. Application for appointment shall be made in writing, shall be supported by the affidavit. Is it right?
Yes.
Receiver other than the official receiver has to give security. Next, the security is to be given, still 5 minutes or more. The security is to be given to the satisfaction of the registrar. He has to provide a personal bonds with the number of sureties required by the registrar. The personal bond will be double the amount of the annual rental value of the property or the total value of the property which the receiver is going to administer. Within a week of appointment, the receiver will have to submit a report providing the details regarding the property such as inventory of property or books or accounts. Once he is appointed, within a week means, can you say the 7 days? Suppose the next day falls, the 7th day falls in holiday, then it should be the next day. Who said? The General Clause Act says.
General Clause Act says that.
Yeah. The registrar will give the direction on where to invest the money received by the receiver from the property. Generally, such money is submitted in scheduled bags or government bonds. Now let us see what are the powers of the receiver. Under Order 40, Rule 1D, powers of the receiver are provided as the following. 1. Collection of the rents and profits arising out of the property. 2. Application and disposal of such rents and profits. 3. Execution of document as the owner himself. 4. To institute and defend the suit. 5. Such powers as the court may deem fit. Those are all the powers given to the receiver to take care of the property and do the things. Also, there are indirect powers which a receiver enjoys, being the hand of the court. For example, if a person obstructs or interferes with the receiver's right to possession, it will amount to obstruction in a court of proceedings. Such a person can be made liable for the contempt of court. Good. Similarly, property in the hands of the receiver cannot be attached without the leave of the court. So court permission is must when the hands of the receiver will be there. So now let us see The court has the discretionary power not to confer all the rights on the receiver. Even if the court has given all the powers to him, he should take the advice of the court, even the powers are given. The advice of the court in all important decisions related to the property to protect himself. So without the permission of the court, the receiver cannot but grant a lease on the property or extend the lease on the property. Bring suits except for the suit for the rent. A suit will be dismissed if not permitted by the court. What are the duties of the receiver? Under 40, Order 40, Rule 3, duties of the receiver are provided as follows. 1. Furnish security to account for that, for what he will receive from the property as income. 2. Submit account half yearly for such a period or form directed by the court. The account basically includes the income received and expenses incurred for the protection and preservation of the property. Pay the amount due to the court. Pay the amount due to the court. Take responsibility for any reduction in the value of the property because of the receiver's willful negligence. Discharge the duties personally and should not delegate or assign any other rights entrusted to him by the court. So whenever a responsibility is given to the receiver, he could not delegate it. So that is clearly mentioned. The receiver has to fulfill all the duties and responsibilities entrusted to him by the court. Whatever the entrusted to him by the court, all that he has to fulfill it. Duties and responsibility. Otherwise, the court can take action against him, means against the receiver, and make him personally liable for any loss which might occur due to his negligence or willful failure to protect and preserve.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आभार प्रचारित सुनि तव उदार